I'm an attorney, and I emphasize healthcare law in my practice. Today we're going to talk about the privacy part of HIPAA. There are other parts of HIPAA, and we'll kind of define what HIPAA is generally. But the part that's important to us today is keeping information private. And why do we need to do that? Why do we need to keep information private? In today's age of electronics, the internet, and all of the proliferation of data out there, and I'm sure you've gotten those dinner time telemarketing calls that come from lists sold off by credit card companies. I'm sure you've also gotten some of the notices from the different credit card companies, other folks out there that are now having to comply with other federal privacy laws. Those notices have been coming in our credit card statements and other places. And one of the things that Congress tried to do, or is trying to do with HIPAA, is create a national framework for the privacy of protected health information, which is really financial, demographic, or clinical information that we store on a patient. HIPAA stands for Health Insurance Portability and Accountability Act. It was passed in 1996 by Congress. All right. Let's talk a little bit about HIPAA and how it applies in our office, how the privacy part of HIPAA applies. There are other parts of HIPAA you may have heard of, like EDI and security and those sections, but what we're going to talk about today is privacy and how that part applies to your office. Okay, privacy is the part of the statute that requires us to keep the protected health information private. And I'm going to keep referring to one key word in what I'm talking to you about today, and that's reasonable. We need to be reasonable in how we apply privacy rules. It's not meant to shut down our business. And there are a lot of myths out there about having to build walls and buy expensive equipment and all sorts of different things that we really don't have to do. We can. Of course, we can do those things. But we don't have to do those things. We just have to be reasonable in how we apply and create policies within our office that help to keep protected health information private. Okay. Let's talk about our office. Let's say we're a dental office and we have operatories, and the operatories are open areas. We've all been to the dentist, and the operatories are open areas where you can oftentimes hear what's going on in another room. Sometimes there are monitors up there. Do we need to build complete walls between each of the operatories and close them off and make them soundproofed? Absolutely not. We do not. Instead, what we can do is implement policies. Policies that when we're talking to a patient, we talk quietly about things that involve the protected health information or that involve the care of the patient. So we have a policy to tone that down. We might have a policy, we don't have to, but we have a policy that says let's use a private room when we're talking about protected health information to a patient. That's a good policy to have. When people are in the waiting area, okay, when they're in the waiting room or near the nurse's station, you might have other patients stand back about 5 feet. And you have the front office folks or the nurses talk quietly to the patients that's up front. Do we have to get rid of our sign-in sheet? That's a HIPAA myth. Absolutely not. Do we have to have a special sign-in sheet that blacks everything out? No. We can have a regular sign-in sheet with the patient name, date, and time. We just can't have a lot of diagnostic information on our sign-in sheet. How about charts? Do we have to have lock-in cabinets around all of our charts? Well, it might be reasonable to put in locking cabinets if the charts are in an area that are easily accessible. So some of it's going to depend on where your charts are now, whether you have a door to lock for those, and whether you implement stringent enough policies within your office so that there's not a pattern of charts being left out or in a place where people can get to them unsupervised. If you have a policy of not letting people back there and there's always somebody there watching in the area during business hours, well, you may not need to make any physical changes by adding locks, locking cabinets, what have you. So all of the policies, and I guess the point that I'm trying to make here, the things that you do in your office are reasonable things to make it so that patients are not, their information isn't easily exposed to other people that might be in the office. Computer screens are a good example. We might have computer screens in an area where if any time anybody walks by, they're going to see patient record information, okay? What we can do is we can turn those monitors. We can turn them so that it's more difficult to see. We can put a glare shield on the monitor so that the information can only be seen from one angle. Those are some samples, some examples that we can use. We can also have a policy that when somebody leaves the computer workstation, they use a screensaver. And since you're viewing this video, you have purchased the HIPAA Safe or HIPAA Simple Plus product. Those products include a protect button. You just pop on the protect button and it blanks out the screen until you come back. So those are reasonable steps we can take to, maybe move the monitor around, use screensavers to keep data private in the office. We use passwords on computer screens, especially if the computer is left in a place where the patient can get to it. Put a password on it. Make it a relatively long password, 8 to 9 digits, but put some sort of password on so that it's not easy for a patient to simply get in. And be sure to protect the screen before they get to it. Another thing that we talked about earlier, if you're in the waiting room talking to a patient about a diagnosis, do it quietly. Talk to the patient quietly about the diagnosis instead of being loud so that other people can hear. All of these are reasonable steps you can take to maintain patient privacy within your physical office. Charts. Charts are a big issue. Are we still allowed to have charts on the door? Absolutely. Just turn them around. Make sure the open part of the chart is not visible. Close it up. Charts out on countertops that you have, close them up. Get a piece of plastic, a 50-cent piece of plastic, and have a policy of covering it up. And another policy you should have is don't let people wander around your office unsupervised. That's not a good way to have things going. Keep people supervised when they're walking around your office. Okay. In some circumstances, there are going to be other things you need to do within your office to get it compliant. If you're using the HIPAA Safe and HIPAA Simple Plus products, they will take you through a general assessment that tells you these are some things that you probably should do within your office to comply with the privacy rules. But then there are some things you may need to do or you may think of doing that are reasonable as well, and you should do those things. And really, it's common sense. It's common sense stuff. So it's nothing that you need to hire a barrage of lawyers or other experts to come in and pay them thousands of dollars to tell you that, because most of it is common sense stuff. Okay. Let's, and you can always hire those lawyers if you want to. Being an attorney, I'm used to the jokes that people make and the comments that go on. And in some circumstances, attorneys are necessary. But in this particular circumstance, I think that law is designed to be reasonable so that we can continue to do business without spending tens of thousands of dollars to get compliant. Okay, we also have to appoint a privacy officer in our facility. And that privacy officer is somebody that writes up these policies about how we do things in our office and then makes sure that the patient rights that are granted under HIPAA are followed by our office. Okay? The privacy officer in a small facility might be the doctor or the office manager or somebody like that. Doesn't have to be somebody that we pay separately to do it. And in many cases, it'll just be a few extra hours that they need to spend every week working on the privacy side, especially with the software. If we're using the software to handle patient rights and print out privacy practice notices and other documents, business associate agreements, so we're using the software to do that, then it'll probably cut down the amount of time the privacy officer is spending to handle these duties. Okay? In a hospital, larger facility, if you're part of a larger facility, you may very well need an independent privacy officer that you hire to handle those particular duties. So it really depends on the size of your office. Same thing with your policies. In a big hospital, your policies are probably going to be a bit more thorough and complicated than your policies are in a smaller office where you don't have as many people and as many activities going on that are going to affect patient privacy. Now that we've talked about getting compliant, the next thing we're going to talk about is the protection of health information after we've gotten compliant. Okay? And then finally we'll talk about patient rights. But let's talk about the protection of health information. I like to explain this in a way that's different than how some other people explain it, but I think it's an easier understanding. It's an easier understanding of the HIPAA privacy rules. And the idea is, generally, you've got to have an authorization from the patient to disclose their protected health information to some third party unless an exception applies. Well, with HIPAA privacy, there's a lot of big exceptions. So there's a lot of times that you don't need those authorizations. And an authorization is a paper that just says, okay, it's okay for you to disclose this information to this class of people through this expiration date, signed patient. Okay? Now, if we had to do that, if we had to get that authorization form from the patient for everything, let's say that the patient comes in, they visit us, and we provide service, and then they don't pay their bill, and we need to send them out to the collection agency. If we had to call the patient and say, oh, patient, we need to get from you a authorization to send your records to the collection agency, the patient would say, no way, I'm not going to give you an authorization to send the information to a collection agency. They'd be crazy to do that, and then we wouldn't be able to do our job. Let's say we have a database of all our patients, and we upgrade to a new version, and we have to send our old version off to the conversion group at the company that makes our software. And there's 10,000 patients in it. If we had to get an authorization from all 10,000 of those people, because all that information is going out to this other group, they're going to have it, they have the ability to see it, we couldn't do our job. We couldn't practice. We might as well just close the door and go do something else, go consult. Okay? Not designed to do that. HIPAA is not meant to cause those kinds of problems. So the general idea that we have to have authorizations is bypassed through these exceptions. And the big exceptions we have to be aware of are T.P.O. And you're going to hear this T.P.O. in regard to PHI and BAAs. And there's just acronyms for the simple things we're talking about. Protected health information, patient chart, can be demographic, clinical, financial information. That's protected. And when we disclose that, we have to have an authorization unless there's a T.P.O. exception or other exception. T.P.O. stands for treatment, payment, and operations. And it's pretty logical. If we're going to disclose information to a third party for treatment purposes, that's okay without the patient's authorization. All right? That's okay. In fact, we can send the whole record to another doctor. Let's say we're at the hospital. We're working at a hospital. Patient comes into emergency, they got to go up to another doctor in surgery. And they're not part of the same doctor group, common health care group. Okay? To transfer the file, if we had to get authorization, would mean a huge amount of paperwork, loss of time, all sorts of problems. Just not reasonable. So under the treatment exception, we could transfer that record up to that other doctor, and we really don't have to get any authorization or limit what we're transferring. So that's the T part of T.P.O. Then we have the P part, and that's payment. Remember we were talking about the collection agency a moment ago? Well, we can't be required to get an authorization every time information goes off to the collection agency, right? So what we have with the payment exception is, in certain circumstances, we can send payment information off to the collection agency or other payment-related services, attorneys, accountants, whomever it might be. Send that information off to them. But with payment and operation exceptions, operation would be that computer conversion. That means for the management and operations of our business, accreditation, those kinds of things, computer operations, software where the data is going to be seen, those things are operations of our business, where PHI is likely to be seen or used by the third party. That doesn't mean incidentally used, doesn't mean that they just walk by and see it, or they're the custodians working in the office and we have policies to keep them out of it, although it could include them. I mean, we can limit who it includes by who we reasonably think is going to see this information. But for the operations of our business, for the payment part of our business, if the disclosure is not to a covered entity can be a health plan, health care clearinghouse, or a health care provider that bills electronically or otherwise uses a HIPAA standard transaction. That's us. Otherwise, we wouldn't be doing this. Okay? Those three entities are covered. If we're going to do payment or operations with somebody other than those kinds of people, we need to have a business associate agreement. Because, if the idea is that I can't sell off a list of information to another pharmaceutical company for marketing purposes under HIPAA, that's one of the ideas, that we can't sell that information off anymore when we get a group of patients that have diabetes. If that's the idea, and then I give it to the collection agency and they can go ahead and sell it, it defeats the purpose of the statute. So for those people, if we're going to disclose PHI, we've got to have this agreement with them called a business associate agreement that says they won't do that either. Contractually, they won't do that, even though they're not a covered entity under the law. So we have treatment, payment, and operations. For payment and operations, and even between covered entities, just to cover ourselves, we should probably have, or we can have, business associate agreements as well. We don't need to have them. It's not necessary. But as an attorney, I always like to document things. You know, cover yourself. For a healthcare clearinghouse, people that are doing those kinds of jobs, it's okay to get a business associate agreement. In the computer program, the HIPAA Safe and the HIPAA Simple Plus, they'll just print those out for you. Okay? So the payment and operations will generally need a business associate agreement. And another rule applies to those payment and operations, which is called the minimum necessary or minimum disclosure rule. The collection agency certainly doesn't need the entire patient file, including x-rays and any other information that we've gathered on the patient. They'll need financial, demographic, maybe some day sheets to do their job. And under the minimum necessary rule, we give them just what they need to do their job. We can rely on what they tell us they need as well. So if the collection agency says, I need this, this, and this to do my job, and it's reasonable, we can give them that. We can rely on what they ask us for. I always say document that. I think that's important, and you should. And the HIPAA Safe and the HIPAA Simple Plus products will let you document that in case you're audited or you ever need to find that information, you can. Or a complaint's filed against the collection agency or somebody else for violating the rules. You always have a listing of what you received and what they made representation as to in terms of needing to do their job. Operations, same thing applies. Minimum disclosure applies. We only send out what they need. All right. So generally we need authorization, but for us to do business, we don't need authorization when it's a treatment, payment, or operations disclosure, as long as we've given the patient a notice of their rights, of their privacy rights. So we really need to do that first time they visit the office, give them this notice, and the computer program, again, prints that notice for us. We'll talk about the notice and patient's rights in a minute. All right, there are other exceptions, too, to the authorization. Let's say a kid comes in and there's clear abuse by the parent. Do we need consent? Authorization? Authorization is a term we want to use. Do we need that in order to send the information to Child Protective Services or the appropriate authorities? No, we do not. We can go ahead and do that. For disclosures related to a potential serious health hazard, to avert a serious health crisis, we don't need patient authorization. We don't need patient authorization when we've got a court order in certain circumstances. For marketing, do we need authorization for marketing? Yes. Now, we can tell the patient when they're sitting with us about a product that subjectively relates to their treatment, but we can no longer sell this to different companies and different pharmaceutical entities and use that out in the marketplace. Not allowed under the rules. And we need to be very careful that that not happen. Okay? Not a good thing to do. There are certain rules related to law enforcement as well. For law enforcement, it depends on whether we're talking about the victim or whether it's a suspect. Okay? And then there's certain information that we can release without documentation. So there are strong limits there as well. So these are some, and for national security. For national security, you know, there have been a lot of terrorist things going on in the United States. In those cases as well, there are rules that allow us to release the information without authorization for national security purposes. And those, of course, these are all common sense, important things. All right, so we've got authorization, treatment, payment, and operations. Okay, treatment provider, we talked about that. And it wouldn't be very good if we couldn't send the records up to a different department or out to another doctor and be limited to a lot of paperwork before we could do that. The patient's care and the quality of care would go downhill. So the treatment provision allows us to send the whole thing out. We're generally going to assume everybody's a covered entity, so we don't have to have those business associate agreements for the T kind of disclosures. Payment is for payment. Operations, P&O, we should have business associate agreements, and we follow the minimum necessary rule. Then we have those other exceptions that I just talked about. Those are the disclosure rules. So we become compliant under that getting compliant that I talked about first, those reasonable steps. Then, from then on out, after we've done that, we need to make sure that any disclosure that we do, we either have an authorization for or an exception applies, and we need to probably record a lot of those disclosures under some of the rights that the patients have. Okay? So the third part we're now going to talk about are the patient's rights. So all the patients that come into our office or our facility have these new rights under HIPAA. And as we move forward after implementing HIPAA privacy, we've got to have systems that track and keep those rights maintained within our facility. The first right that the patient has is for access of their protected health information, their record. Okay? And that can be found in the law in 45 CFR, Code of Federal Regulations, Section 164.524. That will talk about the patient's right to access their protected health information. They have the right to say, okay, I want to come in and see my protected health information. There's some limitations. If it involves psychotherapy notes, we can restrict some of the information that they see. Okay? They also have to pay a reasonable fee for it. They can ask us to put it on media, a disc. They can ask us to photocopy it. We can charge a reasonable fee for the cost to do that. And we have a specific amount of time in which to provide the information to them. It's about 30 days. Okay? It's 30 days under the law that we have. So in the HIPAA Safe program, not HIPAA Simple Plus, but in the HIPAA Safe program, there's a patient request manager, and when the patient requests to access their information under this section of the law, you put it in, it tracks it, helps you get the information together, and then it records and gets them to sign acknowledgement that they've gotten to do that. So that's access. That's right number one. Right number two is the right to amend, and that's in 45 CFR 164.526 if you want to look it up. And it's also in your program. You can go see these and read the actual statutory text in the program. What that means is a patient can come and say, I want to change my records. I want to amend my records. They give us a request. We take that in. And under our professional judgment rights, we can say, okay, that's reasonable, and we'll make the amendment. We don't have to delete. We can redact and add to the record, or we can just add to the record. If the request is outlandish, we can give them a denial. Okay? They can appeal that denial with us and then complain later to the department if we don't do it. That's their prerogative. Okay? If we deny it. If the record was not under our control for the time frame that they want to amend it, we don't have to allow the amendment either. So if it came from Dr. Jones and now it's with us and they want to amend something that related to the Dr. Jones time period, we don't have to allow that. It's not they can go to Dr. Jones to get that. Okay? Because when we allow amendment under 526, we also have to notify all those business associates that may have received the record or the disclosures from us on this patient. Got to notify them if they maintain the record set that we're making that amendment too. And that requires us to do some work. We've got to track all those business associates that have taken in this record. Now the software does that, which makes it easy. But if we're doing it manually, it's going to be difficult to track all that data. So that's the amendment. Patient also has the right to request additional privacy. We're going to give them a notice that defines all their rights because we have to do that under the law. We'll get to that in a minute. And they can request additional privacy. They can say, and it's pretty reasonable. They come into our office and we have open operatories. They can say, when you're talking to me about protected health information, about like a diagnosis, let's say they've got oral cancer if you're a dentist, or it's something serious if you're a medical doctor or hospital. They might say, can we go into a private room? It's reasonable. That's a reasonable request. And in most cases, it's reasonable. And under your professional judgment, you can accept or decline. But take them in to the reasonable. If they want to meet you at a restaurant 20 miles off site, I guess if they want to pay for it, that would be okay. But that's not as reasonable a request because it eats up a lot of time, and it's not possible for you to do that with every patient. So you've got to look at the request, the additional request, and then determine whether it's reasonable. 1, access. 2, amend. 3, request. 4, they have the right to a disclosure accounting. Okay? I like to think of a disclosure accounting like a credit report. We can write and get our credit report. It has 7 years of history of credit. A disclosure accounting, with a few exceptions, lists the disclosures that we've made of the patient's protected health information for 6 years, back to April 14, 2003. So we don't have to go back from there, because April 14, 2003 is the date that HIPAA privacy went into effect. But we have to go up to that time, and then after we pass 6 years from there, it's back 6 years, okay? And that's a report that tells them all of the places that we've disclosed their protected health information, except where it's T.P.O. and several of the other exceptions, okay? Where it's T.P.O., we don't have to include that in the report. But we probably need to still track the T.P.O. stuff in our database, because we do have an obligation under 528. It's 45 CFR 164.528 sets forth the disclosure accounting rules. Under those rules, we need to keep track of the business associates that have received the information so that we can ask them to account for any place they've sent it. All right, and then we need to include that in our report to the patient. Okay, any place they've sent it outside of the T.P.O exceptions as well. So we need to track all that information. The software does that for us. It's real easy, and it'll print those letters out to those business associates as we need to do that. Okay, so they have the right to this disclosure accounting. Now remember, for access, we can charge them a reasonable fee. For the disclosure accounting, I think we get 30 days to prepare that. There might be a 30-day extension in the rule, but there's 30 days to get that ready for them, and we got to do the first one for free. Every 12 months, they get a free one when they ask us for it. Okay, so it's much better to have software because I'm sure we're going to be delving through the records and typing these things up by hand to give to the patients. And remember, 90 to 95% of the disclosure is going to be T.P.O, but then there are those that are not, business associates, all of those things we want to be able to at least track it so that we can provide this under the law. It covers us. Covers us from a documentation standpoint. It covers us from a standpoint that the patient then, once they receive it, they're going to have a difficult time going out complaining either with a lawyer or to the Department of Health and Human Services Office of Civil Rights. Patients have the right to complain. They have the right to complain. And we have to take the complaint in, give action to the complaint. If it's not resolved to their satisfaction, they're told how to contact the Department of Health and Human Services, a regulatory agency that enforces HIPAA. Okay, they're given that information. All right. Who handles all of these rights things? Who's in charge? The privacy officer, who might be the office manager or a specific person designated for that job only at our facility. The privacy officer maintains these particular rights. Finally, the patient has a right to a notice of privacy practices. And this is a real strict thing. We need to give them an actual notice, a physical notice. We can't just post it and have them read it. We need to give them a physical notice the first time they visit the office or the first time we're going to render treatment. I call that the first visit rule. So in most practices, it's going to be when they visit the office, you print this out and you give it to them. We have this electronic kiosk for the software. The software will print this out, or you can use this electronic kiosk that they can read it on and sign electronically in case you're paperless. So if you're paperless, you might want to talk to us about that particular product. But you got to give each of them that notice physically. And then you have to try to get them to sign an acknowledgement that says, I received the notice. And the notice says, here are your rights. You have the right to all those things we talked about. Here are the things we do to keep your information private. We can use appointment reminders. All those sorts of things are outlined in this report, in this notice that the patient gets. Okay? Software prints it, or you use the electronic signature thing, they get it. They should sign an acknowledgement. If they don't, if they refuse to sign the acknowledgement, then you have to document the reasons why they refuse to sign it. All right, so the patients get that. They can read it. They can sign the acknowledgement. We go on. So those are the rights the patient has and the things we have to do once HIPAA is effective, April 14, 2003. That's when it became effective. So now, from now on out, we've got to keep running. So we've got to track all this information for amendment purposes, disclosure, accounting, access. All of that should be tracked in our software. We also have to train our employees on HIPAA. We have to train our employees on what HIPAA is and what it means so they know the rules, because there are penalties if our employees do something wrong. There's penalties for negligence. It's $100 per violation up to $25,000 per year. And there's penalties for intentional violations, so we need to train our employees. That's why you're listening to this tape, so you understand HIPAA. Now, depending upon the size of your institution, if you are a hospital, you might have additional videos that you'll have people watch after this, or that you'll replace me with and have them watch that express your policies. And after you've viewed this, if you're in a small office or a big facility, you'll also go to our electronic policies and review those. Okay, that comes up next in the training manager. You'll use the software to manage a lot of these things. Authorizations, complaints, it's got the complaint manager. All those things are in HIPAA Safe. Some of them are not in HIPAA Simple, but you can always upgrade to HIPAA Safe to get all of the features that manage all of these different systems. Okay, that is really HIPAA. That's how HIPAA applies to our office. We need to have policies, follow the policies, keep things quiet and private, do it reasonably, maintains a system for the patient rights, which is this computer program. So we put the data and the disclosures and everything into this computer program, all right? And we need to be aware of when and when we cannot disclose. We have a disclosure wizard in the program as well that helps us decide when it's appropriate to disclose, okay? So that's really the basics of HIPAA privacy, and in fact it's more than the basics. You've learned a lot of statutory sections, you've learned really pretty much what you need to know to understand HIPAA privacy and applying it in your office. And you've had to listen to me as a boring lawyer for the last half an hour or 40 minutes, and I apologize, but I think it's better for all of us. We're all patients, and it's important that we, in this day of the proliferation of electronic data, keep things private. Keep them private. It's better for all of us. So anyway, thank you for your time. Please go on to the policies in the next video section if you're required to do that. And then take the HIPAA examination that we have available on the system. Remember your incidental disclosures. Don't get too concerned about those incidental disclosures too. Remember, if somebody walks by and they just happen to see something, it's not a pattern, that's incidental. If there's an emergency, it's incidental. It's important to remember that because you still need to be able to do your job. All the things I've said are important, but a lot of times there are going to be these incidental disclosures because we're human. Not everything's perfect. And remember, this thing is meant to be reasonable. If there's one thing I can leave you with, it's that the law is meant to be reasonable. Thank you again. If you have any more questions, talk to your privacy officer and review the privacy policies. Thank you.